A child protective services case is not similar to a child custody or divorce case. A CPS case tends to turn into a criminal case, minimizing your access to certain information and evidence. The course of your life will deviate if CPS comes knocking at your door. Therefore, it is important to have an experienced family law attorney by your side, guiding you every step of the way. Hi, my name is Peter Sayadzad, one of the attorneys here with the law office of Bryan Fagan. Today's video will answer a couple of crucial questions. Is it legal for CPS to ask your child questions without asking you? What kind of questions can a CPS employee ask your child? And how should you prepare yourself for such situations? Before answering these questions, let's differentiate between an atypical family law case and a CPS one. The most notable difference is the change on the opposite side of the negotiating table. In custody or divorce cases, the opposing parties are equally involved. As the opposing party, the government has far less to lose than you. One way to resolve your CPS case as quickly as possible is to hire an experienced CPS attorney. They can create a communication chain between you and the CPS caseworker. The attorneys with the law office of Bryan Fagan are no strangers to the procedures of CPS. They know how to structure a case in terms of arguments to have your child return home. Our lawyers will not hesitate to advocate inside the courtroom if your case requires ongoing legal representation. But how could CPS gain access to my child, let alone ask them questions? Well, CPS has a process in place. CPS receives hundreds of anonymous reports daily regarding alleged acts of child abuse or neglect. Once a report comes through the system, a CPS caseworker or investigator will be assigned. That worker or investigator will reach out to your family to determine whether you are willing to talk to them about the report. Keep in mind you don't need to talk about the case with the caseworker. CPS needs information and evidence to move forward, which is obtained from interviews. If CPS finds evidence of abuse or neglect, your case could go one of two ways. Either your child will be removed from your home, or you will have to undergo a CPS parenting or safety plan. This decision will not be yours. CPS can opt for parenting plans if your child is not in immediate harm. Parenting or safety plan involves you attending courses geared at becoming a better parent or simply fixing issues in your home that have posed a danger to your child. In between all of this, CPS will have the opportunity to ask children questions based on their age and maturity level. These can be simple and everyday questions regarding what your child wants to eat for dinner or who broke the vase in the living room. CPS might even attempt to contact them at their schools, though asking them questions is illegal without your consent. The older your child is, the more in-depth the questioning will likely be. You can contact our attorneys today to learn more about our expertise in CPS cases by calling our office at 281-810-9760. Please subscribe to our YouTube channel if you like this video and press the bell icon to learn more about Child Protective Services and its procedures.